live on YouTube.
All rise. The Court of Appeals First Appellate District of Ohio and the Honorable Candace Proud presiding this session. Please be seated.
Good morning, everyone.
Good morning.
Welcome to the First District Court of Appeals. It's April 18th, and we have only one case for argument today. That is case number C-22-0535, which is Brown versus Board of Education et al. I've been informed that for the appellant, we have Mr. John Forg.
Yes, that's correct.
To argue, and for the appellees, we have William Dieters.
Yes, Your Honor.
Okay, so whenever you're ready, Mr. Forg, how much time would you like for rebuttal, if any?
Your Honor, I would like to say 5 minutes for rebuttal.
5 minutes, okay, I'll be operating the lights in front of you. The yellow light will come on when you have about 1 minute left.
Okay, thank you very much. May it please the court, opposing counsel. Your Honor, this case, basically the underlying case is a negligence case. We're asserting that during the construction of school buildings owned by the Reading Community School District, adjacent properties were flooded, including the Browns, who are the clients. That's the underlying claim. The defense that would have been raised by any of the defendants would have been that the negligence did not occur. And the reason why I mention that is because the school board filed a motion under Civil Rule 19A and 19.1 asserting that there was another party that was necessary to the adjudication of the case. Now, all of the people who my client and was able to ascertain were involved in the what I would say the landscaping and preventing the flooding were added as parties. The school district asserted that another party, the Ohio OFCC, was a necessary party.
And you initially sort of opposed that, right?
Please?
You initially opposed, you had a different position with regard to that.
Yes,
You initially opposed that.
we opposed it, and I originally opposed it because they claimed they had a contract and there was no contract. But then there was an amended complaint filed. In the second amended complaint, they asserted that this was a necessary party and they added the contract. But if you look at the standard under Civil Rule 19A and 19.1, they are required to show that without the addition of that particular party, then their claim would be impaired and they could not assert their own claim. Now, their claim would be a defense to the negligence action, and they're asserting that without the addition of, or the standard would be that without the addition of the OFCC as a party, they could not defend their negligence action.
Well, what did the contract say about the OFCC?
Well, ma'am, let me just say, the contract doesn't say anything, okay? And there was no evidence provided, and if you read the record, there's no evidence anywhere explaining how the contract would have prevented or impaired any of the defendants from asserting their defense to a negligence.
Wasn't there evidence submitted on the percentage interest that OFCC had in the project?
I'm sorry, I couldn't.
Wasn't there evidence presented on regarding sort of like the percentage interest that OFCC had with regard to this project?
Well, yes, but that is what the interest was, that they're considered an owner of the property at the time. But that's not what its issue. What its issue is whether or not they were involved in the negligent flooding of the alleged negligent flooding of the property.
So what you're saying is there was no evidence presented as to liability of OFCC?
Yes, exactly. There was no evidence presented as to the In fact, there was no evidence relevant to Rule 19A or 19.1 that was presented in any case.
So the evidence, pardon me, so the evidence that was presented was it just fiscal?
No, the only evidence
Do you
that
understand what I'm asking?
Yes, I understand.
Was it
The
only
only
with regard
evidence-
to fiscal interest or responsibility or anything of OFCC?
The only evidence that was presented was that there was a contract. There was no explanation of the contract, and there was nothing, except in the contract, it did say that during the time of the construction, because money was coming from the state of Ohio, that they had an ownership interest for that period.
So how
But
was the
that does
ownership
not-
interest, how was the ownership interest established in the record at this point?
It's just, it's not established at all. I mean, they just entered a copy of the contract in there. Now, that's something that they asserted, but the thing is, what you've been mentioning in that interest is not relevant to the issue of whether the party was negligent or not. That's going to be determined by what happened and what caused the flooding. And there's no evidence in the record at all. There was none presented by the school board. There was none presented by the school board in their motion indicating that any of that would affect their,
Would they be liable?
please,
Would they be liable then?
OFCC?
Yeah.
No, OFCC could not be liable because there was no evidence that they were involved in the negligence,
Even though they had an ownership interest?
even though they had an ownership interest, right.
Was there any evidence on decision-making with regard to the project of OFCC having any role in any decisions?
No, there was no evidence at all. And I'll tell you, plaintiff's evidence, and the reason why they included these parties was, and this is not something that's in the record, but it's because it was dealing with the 19A, but the Ohio EPA had a couple of stays during the construction process because they weren't complying with the procedures necessary for maintaining flooding and downfall. And when that occurred, they conducted, on one occasion, they conducted a tour of the entire process where they had the parties that were responsible and had completed in that present, and they went through and they constructed what they did wrong. And those people that were at that time and presented individuals to comply with the EPA are the parties that were named as defendant.
Counsel,
and
what is the
OFCC was
question-
not a party there, and that's why there is. Yes,
What is
ma'am.
the question actually before this court? Because you did not object to the second filing, and then the court dismissed your case, and then you began the process of attempting to refile it, and then there was the Rule 60 motion. So where are we now in terms of the procedure?
The argument and what we're hearing here is whether the moving party, which would be the school board, presented evidence complying with Rule 19B. And there is no evidence, or I'm sorry, 19A. And there is no evidence whatsoever, none whatsoever. And none of the other defendants even bothered to file any kind of motion or supporting motion in the litigation. So there's no evidence in front of this court to comply with Rule 19A. And
Did you waive that issue by not objecting to the second filing and by
No,
saying that the court could decide?
I said that the only, well, first of all, I don't have to prove that. That's a burden of the moving party. And I'm not my client was a plaintiff and was not the moving party. The moving party was a defendant, or the supporting that would be the other remaining defendants. So the person who had to prove that there was an impairment of their ability to defend the negligence action was the school board. And they provided no evidence in that regard. And because they provided no evidence in that regard, there's no basis for claiming that there was a Rule 19, that there was a party, they call it an indispensable party in the rules, that OFCC was an indispensable party. And you'll also find out that the only evidence that the court relied on was not evidence, it was a speculation. They said part of the contract, and they cited a section of the contract, indicates that they have to comply with, I know there was a set of rules. But there was no evidence that they failed to comply with that set
Can
of.
you refile your case at this point? Is there any civil procedure rule that would allow you to refile your case in either jurisdiction, either the Court of Claims or here?
Okay, this gets into the second issue that this court raised regarding whether this was a final order or not. The ruling of the court is a violation of Article 1, Section 16 of the Ohio Constitution because my client can no longer assert their negligence claim. They cannot assert their negligence claim in state court because the court has ruled that they need to add the OFCC. If OFCC were added as a party, the jurisdiction of the Common Pleas Court would be automatically dismissed, and they would have to file somewhere else because OFCC is a branch of the state of Ohio. If the case were filed in the Court of Claims, which would have jurisdiction, there is no viable claim for two reasons. It would be a completely false claim. One is because there's no evidence that OFCC was involved in the negligence that's being asserted, and two, because even if there was a statute of limitations, and the claim when it was filed in front of the Ohio Court of Claims would not be subject to the statute of limitations in the underlying action, but subject to the statute of limitations when the Court of Claims file was submitted, and that would be beyond the statute, which is 4 years under 230509. So there is no claim to be asserted. And because there is no claim to be asserted in the Court of Claims, and because there cannot be any claim asserted in the Court of Common Pleas, my client has been barred by this action in violation of Article 1, Section 16 of the Ohio Constitution from asserting a simple negligence claim.
And counsel, isn't that analysis that you're talking about, whether the statute of limitations has run on OFCC, part of the analysis the trial court should have conducted under Rule 19B?
Well, first of all, the trial court never conducted an analysis under Rule. It is I'm sorry. You are correct that is an analysis they should have conducted under Rule 19B. And if you look at the factors that are listed under there, one of them says whether can be a viable and fair and viable claim. So yes, that would have applied. But the court never considered this case under. The trial court never considered this case under Rule 19B. They only, if you look in their final order, their dismissal is because I failed to comply, or my client and I failed to file another action under Rule 19A. So they never bothered to consider what you have recognized as is a relevant factor that should have been part of the underlying decision. Now, if they had done that, they would realize that there could be no viable claim. And there could be no viable claim if my client were dismissed, even if it's a dismissal without prejudice, which is what would happen.
I just wanted to let you know that if you want to reserve time, you are at your time.
I do have a question.
Okay.
Don't count it.
If you have
against
any
I won't count her question against
Okay,
you.
if you have any
Okay.
more questions, I'll answer, but otherwise I'll sit down.
Okay, so with regard to 19B, and I recognize that the trial court did not look at 19B.
Yes.
It does have language in there with regard to if a person described in A1 herein cannot be made a party, okay? So how is it that OFCC cannot be made a party? How would you apply that to this case?
Well, there has to be two elements for them to be a proper party. One is they have to comply with the statute of limitations, and the second would be that there has to be some evidence on the part of the plaintiff.
Well, the language here isn't about whether they qualify, it's whether they cannot be. It seems to me that language means something different than whether the individual qualifies to be a necessary party.
Well, I think I think what that language means is you have to comply with Rule 19A. The qualification would be the person the person who is being considered under 19B would be someone who's qualified to be an additional party under I'm sorry. The language quoted under 19B means that the person must be a qualified person under 19A. But in order to be a qualified under 19A, you have to be.
But I think it requires more. I think, because
Right.
it has the language cannot. So it
Right.
sounds as if the person has to qualify under 19A, but for some reason cannot be, for some reason.
Cannot be served properly and be admitted as a party, which is what would happen because they're an entity of the state of Ohio. So there was no evidence ever presented that they qualified with Rule 19A, first of all, and second of all, the court never considered Rule 19B. So we believe that the entry, because it is the court's entry under 19A, because it bars plaintiffs from continuing to pursue their negligence claims, we believe that would have been improper under 19B had that been considered. And also, by the way, there's no grounds under Rule 19A, which is what the court based its order on, for dismissing the party. It just means that a party must be added. And,
Thank you.
That didn't occur.
Thank you.
Thank you.
Mr. Dieters.
Thank you. Your Honors, court, may it please the court, I'm Bill Dieters, as you know, we introduced myself, but I'm here on behalf of all the defendant appellees in this matter. We filed a joint brief, which I think you're aware of, and so I'm here to represent everybody. I just want to make that kind of clear. The other thing about this case, and I just kind of recognize from your questions that the procedure of the case is a little muddy, to say the least. In preparing for this, just going through it, saying, okay, what's the posture? But the important part of this is that when the plaintiffs filed their case, they initially did not name the OFCC as a party. I don't know if you're familiar with the OFCC and how that process works in the state of Ohio, but they're actually a co-owner of the project. When a school district chooses to use the state money to build a building, that they are actually the owner. They stay the owner until long after the project comes to the completion phase.
So how is that relevant with regard to necessary party?
Well, we believe it's relevant, Your Honor, because when the district also does that, in order to have the state money, they must design, build, and the whole process must follow the state manual. So essentially, they're an essential party because if for some reason the school district would be liable if the facts ever showed that, yes, the plaintiffs had damages, it's possible that those damages may have been caused because either the school district or a contractor followed a design manual, which was required by the OFCC.
So the OFCC could be liable?
They can be liable,
Okay.
Your Honor.
Was that presented to the trial court? Is that part of the record right now that there are design requirements coming from the OFCC that are part of the project?
Your Honor, I believe so to the extent that there's no record on the case because we were still just in the motion phase of the case. But when the district, when we filed our motion to dismiss, there was an objection by the plaintiffs because they said, well, you have to prove that they're an owner. Then we filed an amendment motion that included our contract. At that point, we provided language, which the actual trial court actually cites. It's on page 8 of our brief. But the school district board and commission agreed to cooperate in design, construction, and closeout described herein as follows, which is part of that contract. There's also a term in that contract that says, no fund or monies or interest thereon shall be spent from any items inconsistent with the provision of the design manual and commission policies unless a variance is approved by the commission. So the reason why there was no evidence, as the plaintiffs keep arguing, is because they didn't object. In fact, there was, in what they filed back, they said that we take no position regarding the merit or lack of merit of the Board of Education's motion to join the party under Civil Rule 19. Should this court determine that it is a necessary party, the plaintiffs just asked for the leave to file a second amended complaint. And they never added the OFCC to the case.
Was the statute of limitations, had that already run at that point?
Your Honor, the statute had ran at that point, but we don't even know if the facility commission would assert that because it's an affirmative defense. To go back to your point, Your Honor, they were able to be served and they were able to be sued. Now, whether or not they had a statute of limitations defense, was something that party had to raise as an affirmative defense, that they were able to be sued.
But I mean, and that wasn't my question, if they would raise it, had it run by the
It
time that
ran
you all
because-
filed the motion to dismiss?
Because the plaintiffs also waited a great deal of time before they actually proceeded in litigation. So I think by the time they filed their initial action, they were pretty close to the original statute of limitations, Your Honor. I
So
don't
they
have
would
the
have,
dates.
so that, if that would have been raised as a defense, then I guess they could join them and then they would be able to use it as a defense to get out.
Well, it appears that they originally didn't object to the joiner action.
Okay,
And then they never amended their complaint to add them.
Right.
Instead, they went straight to the Court of Claims and tried to do a removal action. The Court of
without
Claims-
having added them first?
Without having added.
Oh,
them.
okay.
Yeah. So, and then we ended up back down in the trial court. And it kind of goes to what the notice.
Counsel,
Yes,
why did the trial court not have a requirement to conduct the 19B analysis? Because at the time of the trial court's order, the statute of limitations had run on OFCC, which would make them not able to be joined under 19A. Shouldn't the trial court have conducted this weighing under 19B?
I can only speculate, Your Honor, but I think it's because the plaintiffs waived. They said they had no objection to the facility commissions being added. And it was never raised as a defense or never raised as an issue by the plaintiffs. So the trial court looked at, in my opinion, the contract between the school district and the commission and said, well, they appear to be an owner and they appear to have more than just a fiscal interest in this project. So if you don't have any objection, I think they're a necessary party.
All
But
right,
I'd be
that was-
speculating.
That was at the time of the initial motion, but then the plaintiffs attempted this series of actions in the Court of Claims that resulted in them coming back on the Rule 60 motion. Why, at the time of the motion to dismiss, did the trial court not have the obligation to conduct the 19B analysis?
Well, I think that's kind of precisely why we're here, because we don't even think this is a final appealable order. Because to this day, as we sit here this morning, the plaintiffs have never tried or attempted to name the facility commission as a party to the case. So or presented any evidence as to why they should be, or even made. So I believe the trial court, again, going back to the procedure of the case, said, well, you haven't even named them. They dismissed it without prejudice with I think the understanding that they thought they would name them and then that would become part of the process.
Under 19A, OFCC is a necessary party with regard to subsection 1, 2, or 3.
Your Honor, I don't have that in front of me right now, but I believe they're a necessary party because you can't fully litigate the case because it could be potentially part of the defense. Either the school district would raise them as a co-claimant or possibly one of the subcontractors. And so in order to have all the facts into the particular case, they have to be a party to the process.
That sounds to me as remote. The necessity that you're articulating sounds to me speculative and remote. How is it not?
I guess the question could be, we don't know because, again, we don't even know if the damages actually exist. We have never gotten anywhere into that place. I'm just saying that if two people own a piece of property or two people jointly construct something and you believe it was done through negligence, there is clearly the possibility that one of those parties or one of the defendants in the case might say, well, it's not my fault that it happened, it's somebody else's fault, and they were part of the process. So it would be like saying, I'm just going to sue one of the owners and not the other.
You would always have the other owner as a necessary party, is your argument?
I believe that there could be a possibility where in some hypothetical situation where one owner may not be, but in this particular case, they're actively involved. In fact, if you
But
look
that's the difference. It's not
Yeah.
just that they have an ownership. It's that you're saying that the contract, which the judge relied on, they had some kind of say or input in the design and.
If you actually look at the statute, that the school district is an agent of the commission in the construction of it. So only because we practice in that area without providing additional facts, but the school district can't even make a change order to change any portion of the design without the facilities commission signing off on it.
So what
they
you're
are
saying is the
actively engaged
authority
in the
really
process.
goes to OFCC, and it's been in some way delegated.
Part of the part of the oversight is because the Facilities Commission is going to provide so much funding in the process that I believe that they want all the buildings to be built in a certain way with certain contract guidelines and certain square footage requirements, and the list goes on and on. The design manual's about this thick. So they are actively engaged in the process. They're not just a fiscal pass-through. They are engaged. And so it could be argued, well, in these processes, sometimes you have problems with the construction process, and when we proceed to go after a contractor for not completing something, the school district has to get the Facilities Commission to engage with them.
Can you provide what are the relevant sections that provide the relationship between the school district and OFCC?
Yeah, Your Honor, it's in our brief, chapter 33. I think it's chapter 3318, and then there's a various amount of, but it's cited in our brief on page 15. It's 3318, and there's about 50 subsections of it, but it's essentially in that section. in that
Are there
chapter.
any other relevant sections that, as a matter of law, define the relationship between the school district and OFCC that are not cited in your brief?
I don't believe so, Your Honor. I think that chapter 3318 encompasses the full breadth of that relationship.
Okay, thank you.
So I just kind of close by indicating it is a little confusing based on the posture of the case and how we got here. It's kind of circuitous, but ultimately, we don't believe it's a final appealable order because it's a dismissal without prejudice, and the Facilities Commission has never been named, so they cannot assert an affirmative defense of statute of limitations. Perhaps if they did, and then we had that analysis under Rule 19, is that they need to be in the case or the case should continue. That's something the trial court could look at, but we don't know at
But
this
can they
point.
even refile? I mean, they would be refiling under the savings statute, right, against the board?
That's what we think, Your Honor.
And then if they add another party, would they qualify to refile under the savings statute?
That would have to be something that would be determined by the trial court, but we don't know because it's not our right, it's not our position to assert that defense of a party that's never been named in the case.
Counsel, let's just play this out for a minute. Let's assume that plaintiffs refiled this action in the Court of Claims and sued the existing defendants in OFCC. And I think we all agree that the statute of limitations has run on OFCC, and they're dismissed. That's a second dismissal.
Correct, Your
There
Honor.
is no more savings statute, and the
Well-
plaintiffs are left without a lawsuit at that point.
They may have a lawsuit, it just may not be against these defendants. Because that would be like saying that if I failed to file my case under a statute of limitations, that I have a constitutional right to overcome a statute of limitations. They exist for a reason, and they're held constitutional. It's a requirement of a plaintiff, if they proceed, to know who their defendants should be and to name those within the necessary timelines within the statute, and they didn't do that.
But your initial motion in this case was not a motion to dismiss for failure to name a necessary party. It was simply a motion to bring in the necessary party, right?
Right, and they didn't object to it. They did not object to the joinder, but they never named them. Okay, thank you.
Thank you.
I do have another question.
Oh.
There's a theme going this week, isn't there? We're just reliving yesterday, and we went past time, because the particular judge asked a lot of questions. Okay, so it sounded to me, and I want to make sure that, you let me know if I'm understanding this correctly, okay?
Okay.
It sounded
try.
to me as if the relationship, as defined by relevant section, right, between the school district and OFCC, it sounded to me as if, in some ways, the school district was stepping into the shoes of OFCC, like OFCC had, so that when you were saying, well, anything that the school district is doing, they have to get the authority of OFCC, right?
If they're going to use the OFCC monies.
Okay.
So So typically what happens is OFCC will do analysis of the 620-something school districts, and they'll put them on a list, and they'll identify based on their need and a lot of other factors what their percentage of contribution is. So they may say, in a rural area like in Southeast Ohio, they might say, we'll pay 85%, but you have to pay 15%.
Okay.
But any monies used within that 100%, whatever that number is, they have to follow the design guidelines. They have to go through all that process. A district does have the ability to do what they call local initiated funds and projects where they can use all of their own money as part of a project. But in this particular project, Your Honor, there was no other funds being used. The only funds being used was 100% of that content of this particular project. So they are actively engaged as an owner. And I believe, again,
So I want to understand actively engaged as an owner. Can you?
They go to all the construction meetings. They're part of all the decision-making processes. If the contractor decides that, well, the the architect and design manual say it should be X, Y, Z, but we can't do X, Y, Z, so we have to do A, B, C, they have to sign off on it along with the school district. Any of the design, the initial design, the school district will actually enter into a contract with the architect that the OFCC is a party to that contract as well. The construction management company that might be overseeing the project is in privity of contract with the OFCC and the school. I mean, it'd be like if the two of us were building a project together and we were the co-owners, we would be every lockstep together in the process.
So these things that you just defined for me, if I was to go through and do a detailed reading of 3318, am I going to find that in there?
Yes, you will.
Okay.
Yes.
So how would you define the legal relationship between the district and OFCC?
I would say it's kind of a little convoluted, but I'd say they are co-owners, but the OFCC has kind of the right of veto power over things. So if the school wants to do something and the OFCC says, no, that's not what we're going to do with this money, we can't do it.
But it sounds like co-owners doesn't mean anything other than we both own this. From a decision-making perspective, how would you define the relationship?
I would say that the school district is an agent of the OFCC as decision-making processes go.
So if that is, when I look at 3318, if that's what it seems that it's defining, that it's an agent of, so for the purposes of the saving statute, would you say that it could be argued that it's the same party in some ways, if one is the agent of the other?
Possibly, Your Honor, but again, I think that's what the trial court was inviting the plaintiffs to do in this case. I think the trial court was waiting for them to be named and then to go through that process. That could have been an argument that's made at the trial court level. Well, they're just an agent, so I already...
Obviously, we're going further than anything that happened at the trial court. I recognize
right.
that.
We obviously, to go to your point, Your Honor, we're aware that by naming them, there was going to be a potential statute of limitations problem. But again, we thought they would at least be named, and then we'd either have that discussion in the trial court or possibly in a case of removal, the argument would come up in the Court of Claims. So.
And then you litigate the issue under 19B.
Correct, Your Honor.
Yeah.
And it also, I'm going to say what I think was going to sound obvious to you, that regardless of the contract that was entered, which has been discussed by appellant, that it's really about 3318 that is defining the relationship and why they're a necessary party.
Yes, Your Honor. The contract, parrots sort of what 3318 requires. So it's actually a contract that is a adhesion contract that if a school district wants to enter into a project with the OFCC, they have to sign this contract, and that contract is developed by the Attorney General's office by looking at the language in 3318 and transforming it into a contractual process.
I appreciate your responses.
Thank you.
you.
Thanks.
Thank you. Rebuttal? Yeah, you have about 4 minutes.
Please?
4 minutes.
Okay.
Unless you get more
Almost-
questions.
Almost all I know.
I'd like for you to respond to what I think is obvious in the questions that are being asked of,
Sure.
the relationship as it's defined under 3318, and how is it, because that's an issue as a matter of law.
Right.
That's regardless of the record that's been established, right?
Well-
So how that then would determine that it in fact is not a necessary party, that OFCC is not.
Well,
a
Your Honor,
necessary party.
I think this is the situation. You have two people that are, they have a contract between the two of them. They're each parties to the contract. What should have happened because the issue under the 19A is whether or not the school board's defense, or their claim, it is the word they use, but it would be the defense, is impaired by the failure to have OFCC. If there was OFCC was not named as a party, but the school board thought that there was something that OFC was doing that should have been, would hurt them, their claim
So
should.
let me ask my question a little bit more detailed. If OFCC is a necessary part of the decision-making of the project, if what has been presented by Appellee is accurate, okay, then how is it that OFCC is not a necessary party?
Because this is a negligence claim, and the question is whether or not OFCC or any of the parties was engaged in any negligence, relating to the flooding and
So are you saying that the actual negligence in the decision-making has to be established at this juncture in order to determine whether somebody is a necessary party?
Well, Your Honor, what I would say is that you would, if you were going to say, it's not that they have to establish that they were part of you have to establish how their failure to be named as a party impairs the school board's ability to raise a defense. That's what Rule 19A talks about. And the normal remedy for that, rather than adding a party, would be to file a third-party claim against the, in this case, OFCC, and assert that, based on that third-party claim, there is something that they provided that should be reimbursed, or there's something in that relationship. Now, if that were what had happened, the Ohio Court of Claims does allow, if the state is named as a third-party claimant, does allow removal to the Court of Claims, and there would have been no issue under Rule 19B or rule under 19A whether they were a necessary party, or whether under Article 1, Section 16, of whether plaintiff's claim could continue, because it would have been allowed to do it under that. And what we have here, what we're facing here, and what is that the state, I'm sorry, the school board acted improperly by not filing a cross-claim against them. They probably didn't want to do it because they were getting money from them. So instead, they tried to file what is basically a surreptitious claim. There's no evidence, and they didn't present any evidence. And if you look through this record, there's no evidence that their contract relationship between OFCC and the school board impairs the school board's ability to raise a defense. It's just not there. So
You brought up something that I had thought about and failed to the cross-claim idea. Like, how is this, there's no cross-claim with regard to OFCC coming from the district, which is what you're saying.
yes.
So it's sort of the relationship between that and necessary party.
Right, because if the school board thought that there was an impairment, their proper remedy would have been to file a claim against, it would have been a third-party claim, not a cross-claim, because OFCC
That's
wasn't
right.
a defendant. But they should have filed a third-party claim against OFCC. And that would have allowed the case that would not have affected any jurisdictional issues, because it could have been removed then to the Court of Claims. And that
Counsel?
would have been the proper way to proceed, and they never did that. And they never presented any evidence. And, that's not an issue. The fact that we never they're challenging the way we defense. That's not an issue. The issue here is whether the moving party, which was the school board, is asserting their claim properly and under the proper conditions.
Counsel,
Yes.
how is this a final appealable order, given that the dismissal is without prejudice? Can you address that question?
Because under Rule Article 1, Section 16, there's only two possibilities that my client has. He can either file a claim in the state court. If he files it if the Browns file a claim in the state court, they have to name the OFCC, and jurisdiction would be lost immediately. That's in the Archibald versus Cox case that we cite in our brief. If they don't assert a case there and they assert a case in the Court of Claims, the statute of limitations is expired because it's a new claim, and they have no claim against. They would have no claim against the OFCC, and the case would be dismissed, and that they would not have been able to refile in state court without OFCC under 230519, because that would have been their third service, and that would have been improper. So no matter how you go, it's a final order, because the Browns cannot assert a simple negligence claim of the type that is guaranteed under Article 1, Rule Section 16.
All right, so you're arguing that essentially the dismissal without prejudice is in effect a dismissal with prejudice because there's no refiling options.
That's exactly right. That's exactly right, Your Honor.
Thank you.
Thank you.
Thank you.
Thank you very much.
Thank you both for your arguments today. The case is now submitted, and we will issue a timely decision. Thank you. Have a good rest of your morning.